I have pictures of me, you, Annette, Krista, Haley, and yeah, two of Krista right in the middle of my screen. So
Oh,
I'm going to try to figure out if I can move that to the side.
you should be able to.
Let's
And
see.
I will turn off some of those videos so they won't be
That'd be
as
okay.
big.
So in getting started, I actually, I had all the materials ready and had my PowerPoints together and my notes and everything. And it dawned on me at like crazy early this morning. I don't know, like 2 o'clock in the morning. Was like, there's kind of a first fundamental question of, okay, we got a piece of real estate. And I go through these transactions, and sometimes I see real estate as in a trust. Sometimes I see real estate as in an LLC. What determines what should go where? So there's a fundamental issue here. When we're looking at real estate, we're looking at investment property, rental property. Is it a personal asset or is it a business investment asset? If it's a residence, if it's the person's principal primary residence, that's not a business asset. That's not an investment asset. It should be in a trust before it's in an LLC. So an LLC would be where we put investment properties, rental properties. It's a business asset. It's a business/investment asset, and it should be in a business entity. So that's kind of the first fundamental question. And my goal in going through this class, Kevin and I were joking yesterday as we were talking through this, was like, we were talking through a couple of issues, and he said, "Oh, maybe that's for the second class." We talked a little bit longer, and then we got some of the preliminary questions this morning. And my other response to Kevin was, "Oh, well, maybe that goes in class 3 or class 4." This is a huge topic. It's extremely broad, especially when we start combining the structure of limited liability companies and how trusts and estates interact with those two. So my goal is to kind of give a broad overview, and then we'll start doubling back and maybe starting to get down into the weeds of this stuff, if that's okay. And if you want to, submit some questions into the Q&A or chat, Kevin's going to keep an eye on that. I'll periodically kind of check to see if there's questions, because I'm used to doing these things like in the old world, like, I don't know, years ago when we used to meet in person before this pandemic, of doing these programs and more having a discussion than me just lecturing. So I'm going to stop periodically, check to see if there's questions, check to see if there's issues. Feel free to shoot them in however you want to. And we will, I still can't move those pictures around. Oh, well, here we go. Limited liability companies. So an LLC, they can basically be formed at a high level in two different ways. They can, and this will be extremely relevant as we talk through the specifics of how you form these things and what you file and who owns what. There are member managed LLCs, and then there are manager managed LLCs. And this is going to sound like I'm stating the obvious, but here it goes. In a member managed LLC, the members have the management rights, which would include purchasing real estate, selling real estate, entering into leases, entering into contracts, mortgages, lines of credit, making distributions of cash out of the LLC, liquidating everything. That would be a member managed LLC. Whether it's a single member or multiple members, the members would have that management control. Seems simple. Manager managed LLC is different. You still have the members that are the owners, but a separate management role has the ability to make those types of decisions: distributing cash, selling real estate, entering into leases, entering into contracts. I knew I shouldn't have checked the question. Is there a lien on one's home? Is there any protection by putting the home in a trust, or is it too late? Too late once that lien is in place. We'll get to that. Good question. Now, so that's how the management of an LLC can be structured. Then the ownership. We can have single member LLCs. And a single member LLC is what we call a flow through entity or a disregarded entity, where any profit loss income flows directly to the single members Schedule C on their 1040 personal income tax return. There's no separate income tax return or filing requirement for a single member LLC. Multiple member LLC. This is where things get different. And I'm not going to take us into the weeds of this thing, but a multiple member LLC then means, for tax purposes, it is either treated as a partnership, which is the default, or it is possible that you can elect to treat an LLC as an S corporation for tax purposes. These types of entities, multiple member LLCs, have separate income tax returns. A partnership would have a 1065, an S corp has an 1120S. But there's still a separate income tax return, which then the profit and loss is then allocated out to the members on a K1 statement. So this starts to look even more like a separate living, breathing entity, because it has a separate tax ID number. So how do you actually form these things? Let me take a quick look. All right, so that's another LLC trust. I'll address that one too, about LLC trust, umbrella policy. Great question. I got an email about that early this morning. We'll get there. Okay, forming an LLC, forming a limited liability company, the governing documents, and this is getting into the area where oftentimes I'll hear the comment, "Oh, these things are easy to form. You just hop on the Secretary of State website, you fill out the form, and you're off and running. You have an LLC." That's fairly accurate. But in the articles of organization, that's the document that we file with the Oregon Secretary of State, where the Secretary of State acknowledges the existence of this entity and issues a registry number. And then each year, the LLC, you're not required to refile the articles, but you're required to file an annual report to have it still acknowledged and recognized by the Secretary of State as a valid legal entity. Then, so you file the articles of organization that recognize the entity under state law. Then under federal law, you get a separate tax ID number for the LLC, and you file what's called a Form SS4. Now, I'm going to take half a step back. Regardless of whether you file a single member LLC or a multiple member LLC, you still get a tax ID number for that single member LLC. You don't want the LLC bank account owned by the single member's social security number. Now you're starting to blend and commingle personal assets and business assets. That we got to keep this stuff completely separate. So the LLC bank account, the deed, the property casualty insurance needs to have an additional insured party added as the LLC. There's a number of things, but everything should be signing leases with tenants. That should all be done in the name of the LLC, and accounts owned under a separate tax ID number. All right. Then that gets us the tax ID number. Banking authorization. So in the articles of organization, when you file as a member managed LLC, you're required to disclose the name and address of the members. When you file as a manager managed LLC, you're required to disclose the identity and the address, so name and address of the manager, Member information is optional. It's optional. So a lot of times when people say, "Oh, I've hopped on the Secretary of State website and filled out all this information," and we see that everything is in there, is that a big deal? Well, when I run into folks that are concerned about privacy, public record, public information, keep in mind, if you want to find out information about an LLC, you can hop on filinginoregon.com, click find a business on the left-hand side of the page, plunk in the name of an LLC, and it will show you what's been filed in the articles of organization. It's going to become important in a minute when we start talking about trust and ownership and whatnot. So keep in mind, a manager managed LLC, you're only required to disclose the information for the manager, not necessarily the members. That's optional. Now, in the last 2 years, 3 years, a couple of years, we now have to enter information about, quote unquote, a person with knowledge. And this is part of the Secretary of State and the governing authorities and banking trying to dig down in and find the information about the actual beneficial ownership interest of an LLC. This person with knowledge, it's not necessarily showing that it's the owner, but it's showing someone that has, I think it's quote unquote, intimate knowledge of the assets and the operations of the LLC. Whole deep conversation about that one's possible. So, banking authorization. So if we file as a manager managed LLC under recent banking regulations in the past 5-6 years, if it's a manager managed LLC, the bank wants to see that the members have consented to the manager having banking authority, because we want the manager to have control of the bank account in the vast majority of these situations. We don't necessarily want members. We want the manager to have that authority. So a banking authorization is typically needed to open up a bank account where you show that the members have consented to the manager handling bank accounts. And yes, you can set up a single member LLC as a manager managed LLC, and you're still going to need to show that Jeff as the member authorized Jeff as the manager to handle bank accounts. All right. Fourth document is the operating agreement. So one of the things I run into, two of the things I run into with operating agreements is there's a little bit of a misconception that this is like the business plan of how the LLC works. It's a higher level than that. The operating agreement, it's much more similar to the bylaws of a corporation. So it deals with the profit and loss allocation of the company, deals with the management rights of the company, the voting rights of the members, and possibly in multiple member LLCs, succession clauses. So dealing with what if one of us passes away? There are buyout provisions for the other member in case we don't want, the heirs of one of our partners to all of a sudden become partners with us just because they passed away and their ownership, their membership interest passed to their heirs. So that's broader picture. That's what is in an operating agreement. The other thing I run into with single member LLCs is the comment that, well, you don't have to have an operating agreement. That's fairly true in that if there is no operating agreement, you get kicked into the default rules under the Oregon Revised Statutes. But virtually every financial institution that we deal with in working with the members of an LLC or the managers of an LLC to open a banking account is the bank will require the filed articles of organization, the tax ID number, a banking consent, and They want the operating agreement because they want to see who has authority and who has ownership. All right, let me check some questions real quick. See if we've got.
So far, there's no new questions.
Okay, good. Very good. All right. Moving along. Ownership and management rights. We've talked about this some, and this is going to start playing into our conversation of trust and estates and whatnot in just a minute. So with an LLC, the ownership of the LLC is held as membership interest, or sometimes it's referred to as membership units of the LLC. The management rights and the authority of the manager can be separate, and that operating agreement is what defines that and separates out those powers and those authority. So the ownership interest is membership interest. When we start looking at creditors, that's where LLCs are drastically different than corporations. So let's take like half a step back. Let me give you a little bit of history here. So corporations have existed for eons. And corporations and LLCs are a product of state statute, state law. They're created. They're what the legal geeks in law school, it's what we were told are quote unquote legal fictions. Meaning you can't really go out there and touch, right, Acme LLC. Like you can come here and touch Jeff Patterson. It's a I think of it as a bucket. It's an entity. It's a bucket that holds assets, and it's created and acknowledged by state law, the Oregon Secretary of State and the Oregon Revised Statutes. One of the reasons LLCs came into existence was for obviously limited liability protection. With corporations, the ownership interest in a corporation is shares of stock. And by statute, a creditor can seize ownership of the shares, the ownership interest. And if they seize ownership interest, then they can exercise whatever rights that shareholder has, meaning they can vote, they can sell assets, they can liquidate bank accounts, they have complete control. So with limited liability companies, it's different. By statute, they're governed by what's called a charging order. So a charging order is what's awarded to a credit. So if there's a lawsuit and it's reduced to a judgment, now the creditor has a judgment and they want to go after the member and get access to their membership interest, they shouldn't be able to seize ownership of that. They only get what's called a charging order. So a charging order is, for kind of a very rough analogy, it's similar to when somebody gets their wages garnished. They still go to work, they still have all those responsibilities to their employer, but when they get paid, that ability to get to the money, the creditor can garnish their wages and take a large portion of that money. Charging order is very similar, so that if a creditor gets a charging order against the member's membership interest, when cash comes out of the LLC, the creditor has the ability to seize that cash. Okay? So they don't own the membership interest. They don't actually step into the shoes of the member. They don't have the member's rights. They just have the ability to get some of that cash. You think back to member managed versus manager managed. If you have a manager managed LLC and you have a creditor with a charging order against the member's interest, the creditor doesn't have the ability to go after the manager because the charging order is against the member. So if the manager has the discretion of whether to send cash out of the LLC, the manager can hold cash back. And then it's not seized by the charging order, the creditor. Now, why in the world do I have this charging order jurisdiction note up here? There's basically two types of jurisdictions, and it has to do with the wording in the statute. And the charging order statute can either be mandatory or permissive. So what has happened, some of the older statutes have language that basically says a court may award a charging order to a creditor. And so where, and lawyers have a saying that bad facts make bad law. So where we've had some bad acting LLC members, when the court is kind of looking for a way to make the creditor whole, the argument has been from a creditor that state statute says may. It gives you discretion, so you may award a charging order or you may award something else. And that something else is seizure of the membership interest of the member. So as some of these cases came out, Albright, I think it was Albright in Colorado, a couple of Arizona cases, Nevada, New Mexico, states like Nevada, Wyoming, Alaska, South Dakota, kind of some of the typical suspects, came up with statutes that said shall, so that they're mandatory, what are called mandatory charging order states. So the statute says a court shall award a charging order. There's no discretion, which leads to, I had a conversation last week with someone that was asking about, someone mentioned maybe I should set up a Texas LLC or a Wyoming LLC. That's kind of what's buried in that comment is what type of charging order statute do they have? One of the more popular states is Wyoming. Not only is it a mandatory charging order state, but the requirements going back to, let me see if I can scroll back there. Whoops, wrong way. In the Articles of Organization in Wyoming, there's very little information that goes into that filing for very good reason. They want to be it's very similar to it's very similar to other states that want to be the big corporation state. They want to be incorporated there because of set up a Delaware corporation. There's a reason why, you name it, a lot of huge corporations are incorporated in Delaware because of the Delaware Court of Chancery, their case law, their statutes. So LLC statutes started showing up in these states, in Wyoming, South Dakota, and whatnot, where the required information and the statutes governing creditors was much more favorable to business owners. Anybody see why this is kind of a big topic and probably going to be multiple part class? One of the issues that I'll very briefly mention right now is, well, why wouldn't you just go set up an LLC in one of those states and then plunk your Oregon real estate into one of those LLCs? You can, but then you have jurisdiction arguments of whether you have in personam jurisdiction and rem jurisdiction, so jurisdiction over the entity or jurisdiction over the land. If the lawsuit involves land in Oregon, shouldn't Oregon law govern the land, not just because you put the deed in an LLC that's cited in Wyoming? Deep, long, involved conversation, but that's one of the things when we're looking at these jurisdictions and the charging orders and what are creditors have the right to. A lot of times that's what's behind the comments of when folks say, well, why don't you set up an LLC in Ohio, one of those states, Texas, Nevada, Wyoming. I'm going to pause right there because I'm about to shift gears, and I'm going to check some questions.
Yeah, I was going to say we've got about 4 or 5 questions in the queue. You want me to go ahead?
Yeah, yes, no, go ahead, Kevin.
One is, what's the appropriate cost of setting up an LLC? And I'm sure that varies.
It does vary, and it varies complexity. I mean, I think you can probably see setting up a single member LLC is fairly simple. It involves one person. You get an LLC with, 4, 5, 6 unrelated parties. They're going to be investors, and they don't, not sure they want to have, the one of their partners heirs as members with them if they pass away or what have you, becomes more and more complicated. The known fees, the articles of organization, Secretary of State charges $100 for filing the articles of organization. And I think probably all of the real estate professionals know, when you go to record a deed in Deschutes County, any county, they charge a filing fee. Those fees range across the state anywhere from $53 up to $98. Deschutes County charges $98 for a one-page deed, and each successive page is another $5. So already right there, if you're talking about putting an investment property into an LLC, just the filing fees are $200 right there. And then it goes up from there.
Another question was, what is involved in transferring a single member LLC to a spouse?
That's where we're headed in the next section.
We'll hold on to that. And then the other question on that, which you'll probably touch on then, is does that create a taxable event?
Oh, interesting. Already on the tax questions. Okay. So if a single member of an LLC transfers their membership interest to a spouse, a child, a cousin, a friend, when they pass away, the taxable events. I'm going to say this very briefly. As far as capital gains tax and basis, the receives a stepped up basis as of the date of death value, at least for now. I say that because there's tax proposals out there with the new administration and whatnot of what changes may be coming. And I'm going to mention this to a whole group of real estate professionals right now. It's in the crosshairs of taking away the stepped up basis to heirs as of the date of death. It's in some of the proposals for the tax changes, which would be a disaster. It would be a nightmare for CPAs. But so that's the first. Does it trigger capital gain? No, not unless the heirs sell the membership interest down the road and it's in excess of their stepped up basis. Is it taxable income? No. And heirs receive assets upon the death of the decedent, and it is not taxable income. What other tax issues could there be? So not taxable income. Estate tax. Right now, Oregon's threshold is $1 million. So as long as that membership interest and the rest of the estate isn't in excess of $1 million of value as of the date of death, the estate wouldn't pay any tax, or would if it's in excess of that. The federal estate tax is still extremely high. The threshold for this year is $11.7 million per individual. So it's extremely high. Now, if the question was, if Jeff dies, leaves his membership interest to his wife, is there a tax? Is there an estate tax? No, because there's an unlimited amount that can transfer to a surviving spouse. It's called the unlimited marital deduction. I'm going to leave it at that. Otherwise, we're going to still be talking about taxes at 3 o'clock this afternoon. Kevin.
Last question in the queue right now is, if one party passes away, I think you may have just answered this.
Okay.
One passes party away in LLC, does the other party automatically inherit the property?
No. Great. Okay. So great question and lead into this. A lot of people, I get a lot of questions about, well, it's already put in this entity. Doesn't my membership interest pass easily to my spouse or my kids? Depends on how the membership interest is owned. Because if it's owned by me personally and I die, that is technically a probate asset. Okay. So which means there's no other way to transfer that membership interest other than getting approval from the probate court for my personal representative to sign an assignment of that membership interest to my heirs. Now, there's two other possibilities here. You can do a form of beneficiary designation for membership interest of an LLC. Long conversation. It's possible, and it's also requires a conversation of, do the members want that? Now, if it's a single member LLC, yeah, probably that'd be an easy enough thing to do. But one of the follow-up questions is, well, are there other assets in the estate or other purposes in the planning to create a trust to hold the membership interest? Okay, so think back. Ownership interest of an LLC is held as membership interest or membership units. Now, a revocable trust is a trust where, and I'll show you the specifics here in just a minute, is where the grantor, the creator, still retains all kind of control over the assets of the trust. An irrevocable trust can show up in one of two ways. Either the grantor of the revocable trust died and was the only person that had the right to revoke the trust. Now the revocable trust becomes irrevocable. Or the will of Jeff said, create a trust and hold all my assets in this trust. That is also an irrevocable trust. Okay. Let's move forward slightly.
Yeah, before you do, there's one more question.
Yes, sir.
And this question is basically, would you have to have a corporation inside a trust in order for its assets to be protected should one die? And are trusts required to be made in the state you reside in?
Oh, wow. Great question. Questions. The trust. So let's look at these three roles of a trust, and I'll address the issue of, is it required to create the trust in the jurisdiction where you live?
And before you do, someone asked if you could even just kind of reiterate irrevocable and revocable again, the differences.
Okay. So well, here we go. I'm going to skip ahead just a little bit. A revocable trust. Revocable trust uses the grantor's social security number. It's a see-through entity. It has no separate. It has no separate separation from the creator. So it uses, my revocable trust uses my social security number. It still uses, it flows right to my personal income tax return. It doesn't have a separate tax return. And I have virtually all rights over controlling those trust assets as the grantor. Okay. So the grantor is the creator of the trust. The grantor sets the terms of the trust and says, here's how this thing is going to work, and appoints the trustee to handle the assets of the trust. That trustee is the gatekeeper. They're the role that has the ability to handle the assets for the benefit of the beneficiary. So we have this bucket, We have the grantor, trustee, and beneficiary. Grantor sets the terms of the trust and takes the assets and put it in the bucket. Once the assets are in the bucket, now the trustee handles the assets that are in the bucket for the benefit of the beneficiary. That's who the trustee owes fiduciary duties to handle those assets for the benefit of the beneficiary. So when I create my own revocable trust, I stand in all three of those roles. And I have the ability to put assets in, take assets out. I have the ability to change the terms of the trust, change the trustees. I have basically complete, full control over that trust. So it's a see-through entity. There's no real difference, and there's no creditor protection at that point. Okay? Oregon, so that you'll oftentimes hear the phrase spendthrift trust or asset protection trust. Oregon doesn't allow a self-settled spendthrift or asset protection trust. I can't create a trust, put assets in the trust, name a different trustee to handle the assets for me and get any liability creditor protection. Doesn't work, not possible. Okay? Other states allow them. And guess which ones? I've already mentioned almost all of them. Wyoming, South Dakota, Alaska, Nevada. Ohio, I don't know why Ohio keeps coming up. Like, what the heck is in Ohio that? Anyway, Ohio is one of them. They allow self-settled asset protection trusts. Here's the problem. To create a trust that's valid in one of those jurisdictions, Jeff, as an Oregon resident, can't serve as trustee. You have to have an in-state trustee, which goes along with when you form an LLC in another state, there's this role called the registered agent. And that's an in-state agent that can be contacted, serve notice, serve claims in that state. So in order to have a Wyoming LLC, you have to have a Wyoming registered agent that can receive service of process and whatnot. So that's one of the issues we run into with trusts. Is people hear, I hear Nevada has these self-settled asset protection trusts. I want to put assets in there and have them protected against liability. Well, there's a whole bunch of stuff whole bunch of steps you have to jump through, whole bunch of hoops you have to jump through just to avail yourself of the privilege of having that liability protection. One of them is having an in-state trustee. I'm kind of shotgunning this stuff. Kevin, is there any other questions related to that?
Well, I'm not sure if if she felt like you answered the corporation inside a trust in order for assets to be protected if they die.
Okay, so yeah, great. Thanks for reminding me about that. And here I am, the lawyer, splitting hairs with you. So one of my first questions is protection from what? Okay, because a lot of times one of the things that comes out is protection from the probate process, liability protection, and taxes. So if we put membership interest or stock in a trust, that implies we're going to avoid the probate court process because there's a trustee or a successor trustee who can handle those assets and not have to get court approval to transfer them. It's all contained within the trust document, whether it's a revocable trust or an irrevocable trust. If it's creditor protection, that goes back to, is it the grantor creating a trust and trying to create liability protection where the grantor is still the beneficiary? Oregon, that doesn't work. Now, what if the grantor creates an irrevocable trust? So now we've got a separate tax ID number from my social security number. And I take that membership interest or corporate stock, put it in an irrevocable trust, but I've said the only beneficiaries of this trust are my children. And I have no ability to make distributions to myself. It only goes to my two knuckleheaded sons. Why would I do that? I have no idea. Different conversation. But I mean, they're 11 and 14 for crying out loud. So anyway, but if I put provisions in there that says the trustee can only make distributions of, let's make it interesting, just income for their healthcare needs, their education needs, and no other purposes, with a spendthrift clause and whatnot, there's a very good chance that an Oregon court would honor that if the grantor has liability problems, because I have relinquished all control of the ability to take those assets back for my benefit. What would be even better is if the grantor creates a trust, names a separate trustee, names Wells Fargo Trust Department to make income distributions to my two sons for the remainder of their lives for healthcare needs. And there's a quote unquote ascertainable standard that says you can only make distributions for this. There's a spendthrift. There's ways, that's way off topic, but there's ways that might avail the grantor and the beneficiaries of liability protection. Wow. Kevin, any other questions related to that?
Well, there are other questions in the queue. I just wonder, like,
Okay.
we're already at 11:15. If you have more to cover, I'm thinking maybe you go ahead and cover what, go through what you have, and then we can circle back to all these questions. That way we don't keep everybody on the call just for everyone's question.
Perfect. Okay. So we looked at these roles. Grantor creates trust, and that can be revocable or irrevocable. Sets the terms of the trust, appoints a trustee. Trustee is the gatekeeper. Trustee has now the responsibility to follow the terms of what the grantor set up, and they owe the duty to the beneficiaries to handle the assets according to those terms. We looked at this. A revocable trust has no separate tax ID number. It uses the grantor's social security number, which means it doesn't have a separate tax return. Grantor still has really broad, so boy, if you start digging into the tax laws, this is actually what's called a grantor trust for income tax purposes, which I'll address in just a second. But so the grantor powers, the broad powers, are typically the ability to, quote, amend, restate, revoke the trust. You got this trust document. An amendment is you change one small portion. A restatement, which is what lots of folks may run into when they're doing real estate transactions, is you see this trust that's the Patterson Living Trust, dated, make it interesting, June 28th, 1970. And in 2021, it's still holding assets, real estate. Yep. Then you ask for the documents to send to title and escrow to prove ownership, trustees and whatnot, and you see a document that's dated like 2007. So a restatement of a trust keeps the original trust name and trust date and rebuilds the guts of the trust, so that if someone creates a trust in California when they were still working in San Diego, and then they retire to Central Oregon, and then they want to update their trust and they think they have to create a new trust, they don't actually have to create a new trust. They restate their current trust. They keep the old original trust name and trust date, which means all of the bank accounts, investment accounts, real estate, membership interest, everything that's already owned by that trust stays owned by that trust, and that original date still governs. It just so happens that the restatement is dated June 2nd, 2007, but they retain the old trust name. So that when somebody has a trust from way back and they just need to update it and they move across state lines, we just restate it so that we don't have to retransfer all those assets back into that trust. So that's one of the powers, one of the broad powers that the grantor retains. And they still retain the ability to handle investments, file income tax returns under their Social Security. So they still file a 1040. Now, an irrevocable trust, separate living, breathing, tax-paying entity. So it has a separate tax ID number. It's separate from the grantor's Social Security number. It also requires a separate tax return. And typically, the grantor retains very few rights to change the terms of the trust or put assets in or take assets out. Why would you do this? Number one, there may be some advanced estate tax planning we're trying to do, because I already mentioned there's $1 million exemption in Oregon. Sometimes we create a trust, separate tax ID number, separate taxpayer right, get it out of someone's taxable estate by maybe making some gifts into that trust and using the federal gift tax laws to get some value out of their estate for Oregon estate tax purposes. That probably just raised a million questions, but that it's a separate living, that's one reason why we might create an irrevocable trust, why the grantor is alive. The other way an irrevocable trust can come into existence, or an estate could come into existence holding these assets, is the grantor passes away. When the grantor passes away, their Social Security number passes away. And now that estate or that trust gets a separate tax identification number. The catch here is estates and irrevocable trusts tend to have very bad income tax brackets and income tax rates. What do I mean by that? You take our personal income tax brackets, and the income tax that's paid on irrevocable trusts or estates, they compress the income tax brackets and move them way down the income scale. So depending on the type of trust, once you hit $300, in some situations, $600 of income, you start running up the tax brackets. So typically, the vast majority of the time, income tax in an irrevocable trust or an estate is a bad thing. We try to avoid that. We try to get that income out. Way off topic, but I wanted to at least mention that when we're talking about separate taxpayer, separate tax ID number. Questions at this point? How are we doing on time?
We've got about 8 more minutes to the.
Okay, good. Okay.
Do you want to answer questions now, or do you want to just keep going?
Yeah, if there are some, I know I've got 2 in the email queue here. Are there any others in the chat or the Q&A queue?
Yeah, there's several.
Okay.
So the one is for a small investor, say with 4 rental properties. From a liability standpoint, is it advisable to put each rental property in a separate LLC?
Great question. So here's the considerations. We talk about liability protection. Before you even start talking about LLCs, insurance coverage, whether it's appropriate coverage for property casualty or an umbrella policy. So you always, that's your first line of defense. It's then when that's not a warm enough blanket to sleep under, then you look at creating entities. So the first step is, okay, if the liability, because you've got to look at potential personal liability, personal assets, the value of the real estate, the tenants, what clientele and whatnot, what is the real risk? Because even looking at the risk, you got to look at, okay, are we talking about a brain surgeon? We're talking about someone in a high risk profession, where you're thinking about personal liability against the rental properties, or is it more along the lines of tenant liability, slip and fall? Some of the may have, I make this. I was talking to a friend the other day in the real estate industry, and I have always kind of made this joke about, well, what if that tenant's like running a meth lab out of the garage and the garage blows up from right? And then that happened a few years ago, and one of my friends that owns a property management company, she's like, dude, if I ever hear you make that joke again, because my tenant just had that happen. So if you're looking at that liability, okay, if it's the liability against the property, at a minimum, you want, in my mind, you want one LLC. Then you start looking at what's the risk and what's your level of comfort. Ideally, the paranoid attorney is going to say, well, we should have separate LLCs for each rental property. Sometimes folks are like, I don't want to pay all those tax returns, all those annual reports, all those filing fees and whatnot. So then we start looking at, okay, so level of risk and similarly situated properties. Sometimes I'll have folks look at it, okay, I've got a commercial building, and then I've got a triplex, and then I've got a single family residence. Those are different clienteles. Those are different purposes. Those are different uses. I would separate those out into separate entities. You got the commercial real estate LLC, you got the single family residence LLC, and then you got the triplex LLC. Well, what if you own 3 single family residents on the same street, neighboring each other, and then you've got, an apartment building in Sandy, and then you've got a triplex out in Prineville? Even different areas of the state. I would separate those out. Well, what if it's just the 3 rental properties that are next door to each other over in Northwest Crossing? I don't know, maybe just put them in one LLC. But the issue with the multiple properties and the multiple potential liability is, if there's a lawsuit and there's a creditor problem, it's against the owner, which would be the LLC, eventually to the member, but the owner is the LLC. So if there's 3 or 4 or 10 rental properties sitting in one LLC and there's a lawsuit, then it's going to subject those 10 rental properties to the one liability from that one property. So that's, in my mind, when I'm walking clients through this, that's how I'm looking at how do we divide this up. It's like, well, what's your level of comfort? What's the risk? What's the clientele? There's a handful of things to look at and walk clients through when we're looking at this stuff. And it always starts with, how I mentioned, insurance coverage. Kevin.
Yeah, another question is, if a number of people have a claim in a trust, but only one trustee, can the others force the trustee to sell the property after a grantor passes away?
It's not like a bankruptcy proceeding where a creditor can force a sale, but the trustee first has the responsibility to pay the tax man, pay the cost of administration, pay secured liabilities, unsecured liabilities, and eventually make distributions to the beneficiaries. So yes, there could be a situation where the trustee really has no other option than to sell the property, pay off the creditors, because you're not going to pass the creditors down to the beneficiaries. But so there's a situation where, trustee could have no other option but then to sell the property.
So another question is, when one spouse dies with a revocable trust, does the other spouse have the right to sell off and spend all the assets of the trust without the permission of the beneficiaries of the trust? Or do all beneficiaries need to sign off?
It always depends on what the trust says. So if it gives broad discretion, if the surviving spouse is the trustee and the beneficiary, and it gives them extremely broad discretion to handle assets, sell assets, then they don't necessarily have to go to the next generation of beneficiaries or the contingent beneficiaries and get approval, knowing that's the backstop. There's no trust police, and we're not in the court system at that point. So there's always a potential that unless the trustee has extremely broad discretion, the surviving spouse, they may have some issues with the beneficiaries. I'll go ahead and mention this. So when would they? Some of the language that I've seen in trust that can be problematic is my trustee, my surviving spouse has broad discretion to make distributions of income and principal for health, education, maintenance, and support. And they add this little phrase, in the lifestyle that they enjoyed while the grantor was alive. That can be limiting language. That can, because, now he, surviving husband, he's taking cruises all over the place every year and he's spending all this money. They didn't do that when she was alive. Is that violating the terms of the trust? Maybe, may have some beneficiary problems there. So it all depends on what the terms of the trust says. And Kevin, I wonder, how are we doing on time? We're there.
We're there, but we do have a couple more questions if you have time.
Yeah, I do. Yeah, I have time.
Okay, so I wanted to circle back to some of the questions that you were holding back on, just to make sure that we did answer those. And one is, is there a lien on, if there's a lien on a home, is there any protection by putting the home in a trust, or is it too late once there's a lien in place?
Too late. Yeah, too late at that point. Sorry, that's a quick, easy question. Quick, easy answer. Yep, too late.
The other one was the river frontage one. If you own property on a river, owning to the river, and a hiker or someone trespassing person falls and sues you, is it best to have the property in an LLC or a trust? And in this case, you just have a married couple, no other members. And and they would have an umbrella policy, obviously.
Umbrella policy, as long as it's not primary residence, and it's probably an appropriate asset to have in an LLC, particularly if you run like VRBO or short-term rentals, or probably better off to have it in an LLC. But that also goes to, I don't do any litigation. So now you're treading on areas where I have secondary knowledge. Is if you're negligent in maintaining the property, like you knew people came through there all the time, and that bridge, you knew it was rotten and eaten up by termites and had problems, and somebody falls and gets seriously injured, there may be some negligence there, and it doesn't matter if it's in a trust, an LLC, or whatnot. So if there's negligence or gross negligence or bordering on intentional misconduct, none of this stuff is going to protect anybody. Whether you got it in a trust or an LLC or personally.
The questioner responded and said, in this case, it'd be a primary residence with no renters.
Yeah, nope, won't, because then you have the plaintiff has the argument, there's no business purpose for that LLC. That's their residence. That doesn't even belong in that LLC. You should disregard the LLC and just treat it as them personally owning it. That's typically where those litigation arguments go.
Is it beneficial to form a trust before the grantor's primary residence is sold?
Well, that's interesting. Before it's sold, because a lot of times the question comes up before I buy it. Before it's sold, unless there's a concern that the cash the proceeds from the sale come back to the grantor and they're holding $400,000 in cash, and they pass away in the interim, and you have to probate that cash account. Yeah, absolutely. Then a trust should be in place so that those proceeds, so that we don't risk, a large amount of cash like that having to go through the probate court system.
And then Sam had a question with the above questions.
Wait. Is that Sam Delay?
No, it's Sam Hayden. So
Okay. Oh, I'm totally fine. I'm kidding.
yeah. With the above questions, he goes, what if there's no death involved? Sam, correct me if I'm wrong. You're referring to the question about owning a property on the river, or is there a lien on a home and the home's trust too late to put in? I'm not sure which above referring to. Which question were you referring to then, Sam?
So Sam, if you're
transferring an LLC to a spouse when there's not a death involved.
So if there's not a death involved, you transfer your LLC membership interest to your spouse. Is there tax implications? Oh, sorry. Like the chat box was, oh, good. Correct. Are there tax implications? Typically, no, because there's no gift. There's still an unlimited marital deduction for lifetime transfers. So it's not treated as a gift. If it's outright from Jeff to Gina, she owns it outright. Not a taxable gift, so not an issue. Not taxable income to her. Now, any income that spins off of that in the future is taxable income to her. And if we were married filing jointly, it's a wash anyway. But yeah, Sam, I hope that answered your question. But no, that doesn't create a taxable gift.
Okay, Jeff, I don't see any other questions in the queue. So I just want to thank you very much for this class. The only comments so far were when's the next class? And so I'll talk to you, Jeff, later about maybe seeing about if we can do a sequel to this. And then another question unrelated to the topic itself is, would you be willing to make the slides available to the attendees? And I can talk to you about that later too.
Sure. Yep.
So, and then for everyone who's still on, thank you all for attending. Appreciate you all being a part of this. This was by far our most well-attended seminar to date for a webinar. We had over 100 people on the call today. So thank you all for being a part of that. And we will have your continuing education course credit certificates emailed to you, hopefully by the end of the week. And with that, we'll go ahead and try to include a link to our website where this will be posted. The recording of this class will be posted for your review as well. So if you have any questions, feel free to reach out to us. We appreciate all of you. Thank you very much. And again, thank you, Jeff. This was amazing. Great topic, a lot of great information.
My pleasure. So, thanks for having me, Kevin. I really appreciate it.
Yep, you bet. Thank you. Okay, with that, we're signing off.
Thanks, folks.